Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a really interesting book which will be fascinating, I think, to royal watchers, fascinating to lawyers, fascinating to people involved in anything to do with defamation, privacy and all the other areas that are of interest in the tabloid press in particular. The book title is Celebrity and Royal Privacy, the Media and the Law. It's a first edition of a book, actually, just come out, by Robin Callender Smith, and I hope I've spelled his name correctly because it's sometimes, for some reason, the spell checker gets the name wrong because of his first part of his surname. So apologies if there's any mistake, but it's Robin Callender Smith. The book comes to us from Sweet and Maxwell, which is part of Thomson Reuters. And Elizabeth and I talked about the book in some detail because it's not just a review that we've done for the web and the journals. We've done a little article on it as well. But what we've said is this is a book for media lawyers and journalists everywhere. The complexities of celebrity, privacy and the media. That's really our subtitle. Let's look at the book first of all anyway. It's a hardback. There it is there, nice little hardback. All the flashing bulbs that you see. If you've ever had the misfortune to be snapped like that, and I have, it really is very disconcerting, I can tell you. There's the spine, and then there's the back of the book there. And it sets out in general terms, mentions some of the cases in very simple name terms. Now the book runs to something approaching 550 odd pages. The index is really quite detailed and it's quite helpful. The index is actually in paragraph numbering, not in page numbering, so you have to know what you're looking for. Now there's a directive which is mentioned at the back of the book, and we'll talk about that a little later. And the Defamation Act is nicely covered as well. That's the 2013 Act. Then you've got the Data Protection Act, so you've got a lot of legislation that is mentioned. And then some of the earlier legislation there. Now if we go to the front of the book, that is actually the main front page. And as you can see, the actual author is Professor in Media Law, Queen Mary University of London, barrister, Gray's Inn, and a judge of the first tier tribunal in various areas. Now this is the actual contents section here, which shows you it's split into various parts with key concepts and then moves on to various areas. There are three basic parts and then some appendices which includes the various important pieces of legislation. Then what you've got is an index at the back. There's a nice dedication which is there, which I always like to show to everybody so you can see who it's dedicated to. And a preface, and the preface is certainly worth reading to give you some idea of what this is about. In fact, it talks about a particular person called, and some people probably won't remember him, Dr. Leonard Arthur. This is a doctor who was charged with the murder of a 3-year-old boy. And that was a very important case at that particular time, but it starts off with that particular case and how it was reported. There is the table of cases there, quite a lot of cases as you can see, then table of statutes, the useful statutory inclusions at the back, then statutory instruments there, and then you've got the European legislation as well. And then as I say, it's split into various parts, and it starts off with the introductory section, the key concepts. Then you can see the structure of the book. There's paragraph numbering at the top there. Then there are footnotes as well. So very much the house style for Sweet and Maxwell. And you've got the paragraph numbering at the sides there, which you'll find very helpful if you're actually looking for things. Then if you open up in the middle of the book, you've got the same sort of thing. Now you'll know a lot of the cases that are covered here will be cases you are aware of. Obviously Campbell is mentioned, and quite a large number. And the famous people. It's dealing not just with royalty, but of course famous people as well, because they make great stories, of course, for the tabloid press in particular. And it's really about balance, because we do still have the basic issue of whether people are entitled to privacy or whether in fact there is the freedom of expression. And of course the issue, as always, hasn't really been determined, because it's a fine balance between maintaining the rights of someone's right to express themselves, but at the same time guarding effectively well-known people, guarding a certain amount of their privacy in private matters. And so that's really where the balance comes in. It won't ever, I don't really think actually it'll ever be resolved. I've been to many conferences where this has been discussed. Frankly, but a sense would come into it normally. It doesn't, because it's about money, and that's really the biggest single problem. The royal family and celebrity people, they are money, they're news, they make money for people, so therefore they are bound to be the butt sometimes of extremely unfair reporting. And that really is when, if you look at it logically, that jurisprudentially is when the law should step in. Whether it does or not is another matter, and whether you've got a pocketbook full enough of money to pay to try to stop these people is also a problem. Anyway, enough of that. Let's talk about the book itself. It's privacy versus press freedom, as I say. The debate rages on and will continue to do so, especially when it comes to the often vexed relationship between pesky journalists and aggrieved celebrities. You can see the balance. For journalists then, as well as lawyers, this book, which is a recent publication from Sweet and Maxwell, is quite a find, for it's written by Robin Callender Smith, who's an experienced media lawyer, judge and academic, who started his career as a journalist before he became a barrister. The preface recounts the details of his enviably varied career, which one of these days should inspire the publication possibly of another book. No doubt there's probably quite a lot of great interest there. Experienced then both in the law and the media, the author is no mere theoretician. For example, he worked for the Sunday Express under Sir John Junor, where he found himself added to that Sunday paper's Saturday night rota of barristers, working as night lawyers, checking the pre-publication copy for libel, contempt, copyright and privacy difficulties and potential pitfalls. And of course, Private Eye was another one where quite a few people were involved, because quite often they really were sailing very, very close to the wind. And of course, most newspapers did have what John Junor had at the Express. Now, following his finals then at Gray's Inn, Professor Smith taught newspaper law to aspiring journalists, including Alan Rusbridger, the former editor of The Guardian, and Frances Gibb, who continues to do distinguished work as legal editor of The Times, and excellent she is too. And as an information rights judge, Callender Smith also deals with such issues as freedom of information and data protection, which is why the legislation is included at the back of the book, and I think that's very helpful. It does pad the book out a bit, of course, but it's useful to have that legislation there to refer to very, very quickly if you need to. So unlike most student and practitioner texts on media law, this book concentrates on the specialist area of celebrity privacy in the media, which is a hot topic, frankly. It examines the various privacy regimes in English law that can and may be used by celebrities. These are elements, says the author, that protect such privacy and those that permit intrusion in the interests, one may assume, of freedom of speech. And I think that's a very liberal interpretation personally, because sometimes the intrusion goes well beyond what I think is either reasonable or in any way proportionate to what is going on. But again, it does get down, because of the common law concepts, it will get down to individual cases. Now, the resulting tension inevitably creates conflict between what some wish to hide and what the media wish to expose. The prime issue stressed throughout the book is the principle of proportionality, a judicial concept which presupposes an articulated and visible rule of reason aimed at striking a balance between either protecting or permitting interference with an individual's seclusional or informational privacy. There's some interesting words there. But again, you can see we're still getting back to the balance issue at the end, even though they can use some rather interesting words. The paradox and the problem in all this is that the resulting body of law and the procedures for its enforcement are rendered less effective, to say the least, by internet platforms like Facebook and Twitter, in other words, the social media, which some regard as unregulated and therefore unruly. In fact, I'd say a lot of people regard it that way, and in fact, at some stage, something will have to be done. There's a problem, though, and that is the international perspective. Now, this, declares Smith, of course, this whole issue, quote, presents a major legal challenge for the future. And that's exactly why I think this book is very timely, because we are not anymore looking at localised information, which is available, say, in England and Wales, but not in Scotland or Northern Ireland. Classic examples, and the one that brought, I think, everything to a head some years ago was the Spycatcher litigation, where you could buy the book in America, you can buy it here. I made a joke of the whole thing, and it showed very quickly how global our community had become. Let me conclude by saying, in the meantime, while this major legal challenge for the future is taking place, the book elucidates the challenges presented by a rather vague, vast range of actual celebrity cases, some still quite recent. That includes Naomi Campbell and Max Mosley, and also to the still topical concern about those spider letters penned by Prince Charles, which I have to say really disappointed The Guardian, because they thought they got a real scoop there, and it turned out the public were really rather interested to know what Prince Charles thought. So at the end of the day, it was a little bit of an own goal, I think, for The Guardian on that one. And in many ways, probably, when we're looking at the royal issues of privacy, and that is about privacy and protection, and the real question is, would the Prince of Wales, or the future king, should he be involved? The answer, of course, is yes, he should. And in fact, I don't think it's really our business. We don't want to know what the Queen says to the Prime Minister at their meetings, because they're private. And I think you have to get that balance. And really, at the end of the day, there has to be some protection. If the press and certain unscrupulous individuals can't behave properly. And that's really the bottom line on this. Now, having said that, part 3 of the book discusses in detail the media issues involving the monarch and members of the royal family. It's important to look, for instance, the case of R versus Burrell, the Burrell case in 2002, and the effect of the monarch's silence, which can, of course, have a particular effect. That, I think, is an important point, whatever one's views, whatever you've read in the press. And I will say one thing, and that is, don't believe all the nonsense that's in the press. They make things up. I'm afraid they do, and we just have to put up with it. But at the end of the day, it is about balance. So finally, what do I say about the book? It's learned and it's authoritative, yes. It's a boon to researchers and practitioners in what's an important area of law. And don't, of course, forget journalists who should read this, in my view. Not that the paparazzi would bother, I hasten to add, but I certainly think the other more serious journalists should be well aware of how far they can go, because there are scoops and scoops, frankly. It's copiously footnoted. It contains useful tables of cases, statutes, statutory instruments and European legislation, and it's undoubtedly an essential purchase for the well-stocked Media Lawyers Professional Library. And I would expect every national newspaper to have a copy of this, and I would expect all the local ones to as well, so that they're well aware of how far they can go. Because I do think when you look at the general concept of ignorance of the law is no excuse, these people do know when they're going for a story how far they can go, and they go over the line occasionally because they think they can get away with it. Unfortunately, in the past they have sometimes, because it's not very easy to sanction them. And that really is one of the issues, but perhaps that's for a second edition, I don't know. The publication date is cited at 2015, and I'm reviewing this at the beginning of 2016. There's the book again, with the old snappers at the front, and then there's the back bit there, and then just opening it up in the middle. This is the Bribery Act. You see, quite a large part of the book is actually given over to the statutes. In fact, the Bribery Act starts off the statutes section, which is the appendices there. You can see it lists the various statutes. And the last chapter, which I referred to at the end, which is about the convention of sealing of royal wills, for instance, that sort of information. We're talking specifically in this chapter and the final chapters about the way in which the royal family are treated. Obviously the royal will is an important area in its own right. The Sovereign Grant Act 2011 is also mentioned. So there has been quite an attempt by Parliament to deal with some of the points, and then you've got quite a large number of cases which you can see listed again there. I found this book fascinating, and I think it is very much a book for the future, because wherever we go with social media and regulation, there is going to come the day when we have to know about things, but there has to be some common sense brought back. At the moment, there isn't as much as there should be. I'd like to thank Robin very much indeed for doing this work. It's a splendid book, and to Sweden Maxwell for undertaking its publication. As I've said, you as journalists, I'm one as well, read it and keep it. It's a good book. Thank you. Bye-bye.